All right. Hello, everybody, and welcome to today's webinar. Very excited to have you with us. My name is Alex Proctor, and I'm the Chief Trust and Privacy Officer at Captain Compliance. As of today, there is 1 week to go before Maryland's new privacy law, which is called the Maryland Online Data Privacy Act, or MODPA, goes into effect. It was signed last year in May, and now it's officially going live on Wednesday, October 1st. So, if you haven't been tracking closely, one thing that you should know is that 2025 has been a very active year when it comes to these new privacy laws. This is the 8th law to take effect in 2025 alone, and it brings the total number of states with active comprehensive privacy laws up to 15 or so, depending on exactly how you count and what you consider a comprehensive privacy law to be. Since we're on the subject, here's a quick visual that shows exactly which of the states now have active laws, and also which states have passed laws that are going to be going into effect soon. You'll notice that I still have Maryland as pending. I didn't want to jump the gun. I'll update my chart next week. By the way, if you know a thing or two about privacy, you may be wondering why Florida, Washington, and Nevada are not colored in on the chart. All of these states have important privacy laws, but they're all a little bit more limited in scope than we see with the comprehensive laws like Maryland's. Looking forward, we're going to have hopefully a few quieter months to finish out 2025, and things will pick back up in January. Indiana, Kentucky, and Rhode Island are all going to see their new privacy laws go into effect in the new year. So I think you get the picture. There is a lot going on in this space, and there's just so much information for businesses to keep up with when it comes to these new state-level privacy requirements. This is especially true when it comes to Maryland, and that's why we're all here today. Normally, I've been having some fun recording videos to explain the unique aspects of each of the new laws. I've been doing videos on privacy litigation too. So you're seeing some of the thumbnails of these recent videos that I've done. Today, I really wanted to switch things up and cover Maryland's law in this live and more interactive format. So thank you for joining the very first live stream that we've done. One of the main things that I want to emphasize up front, MODPA is not your typical state privacy law. But before we talk about all the ways in which MODPA is so unique, still want to acknowledge that it has the same high-level themes as the other 14 state laws that are currently active. The graphic that you're looking at shows the themes that we tend to see across all of these state laws. We have notice and transparency, purpose and processing limits, risk assessments, consumer rights, protections for minors, and non-discrimination. All of these themes apply to MODPA. It's just that it takes some of them to a new level, and that's especially true for the second one, purpose and processing limits. Frankly, the reality is, MODPA might be the strictest privacy law that we've seen in the entire country. There could be a couple other contenders. California's CCPA, Washington's My Health, My Data Act. They might have strong cases, but Maryland is somewhere in that top 3. It's going to pull more categories of businesses into its scope, and it's going to feature higher violation penalties than just about any other state. It also has unique requirements that we don't see under the other state laws. So my goal today is to give you all the key information you need to know about MODPA if your company operates in Maryland. And as I do this, I'm going to be trying to point out the areas where Maryland's law is unique or otherwise different from the laws that we already have in effect. That way, if you're operating in multiple states, you'll have a feel for the special things that you may need to do in Maryland. Here's our agenda for the day. We'll start by going over the very basics of MODPA. The most important thing to pay attention to here is going to be the scope of applicability. From there, we'll go over the full set of consumer rights that the law provides. These are going to be pretty similar to most of the other state laws. So the most interesting part of that section will probably be when we talk about Maryland's right to opt out and the 3 different ways that that can be exercised by data subjects. Next, we'll cover a laundry list of controller and processor requirements that come along with the new law. This is where we'll spend most of our time together. The most unique aspects of MODPA are going to come up when we talk about personal data minimization, sensitive data, consumer health data, and children's data. So that's the part you really don't want to miss. Then towards the end of the stream, I'll share details about MODPA enforcement, what to expect there, and then we'll wrap up by going over final recommendations. A few quick things to mention before we get into the material. So first, if you're preparing for MODPA compliance, you want to engage your legal team. In this session, we're going to be talking about ways in which you might respond to the law's requirements. I'll be pointing out decisions that you might have to make and so on. Make sure your legal team's involved, and they can help you make the most appropriate risk decisions for your own business. Second, if you're not already aware, my company, Captain Compliance, is a privacy technology provider. And as it happens, we offer technology that simplifies privacy compliance, including MODPA compliance. This is an educational webinar, but you will see glimpses of our tooling because I'm going to use it for some illustrations. If you do feel that you need help, we can connect out of band. I'd be more than happy to take you through our platform and fully explain how we can reduce your privacy risk exposure, both in Maryland and also beyond. And speaking of potentially helping you, as our way of thanking you for watching this video, I'd like to offer anyone that's watching a complimentary privacy checkup. I started doing these earlier in the year, and businesses are finding them helpful. Expect a 30-minute session. We'll go through your website together and assess your privacy risk exposure. I'd say that on about 90% of these checkups, we find some issues and misconfigurations, a lot of times with cookies that are firing or not firing. Sometimes we can fix them that very same day. If you do need help on the technology end, we can obviously help you with that too. So if you're interested in a free checkup, you'll find the sign-up link in the video description. With that out of the way, let's get into it. So as we start to kick off our review here, I think it makes the most sense to look at the basic definitions and building blocks that establish the scope of this law. I'll be the first to tell you, this section is going to be a little bit dry, but stick with it because we're going to be calling back to it throughout the presentation. At the highest level, the whole purpose of MODPA is to protect the personal data of consumers. And of course, this requires us to understand what a consumer is. According to MODPA, a consumer is an individual who is a resident of the state of Maryland. The definition also excludes individuals who are acting in commercial or employment contexts. So basically, what this means is that it applies to Maryland state residents in their personal capacities. It's not going to apply to residents when they're acting on behalf of a business or as part of their job. Much like the other state laws, MODPA grants Maryland consumers a robust set of privacy rights, creating a whole lot of obligations for controllers and processor. We'll talk about those rights and obligations later, but for now, let's consider the difference between a controller and a processor. So according to MODPA, a controller means a person that alone or jointly with others determines the purpose and means of processing personal data. In contrast, a processor is a person that processes personal data on behalf of a controller. By the way, when it comes to these definitions, a person can be a natural person, like an individual human, or a legal entity, like a company. Just wanted to point that out. The next major element that we need to define is the concept of personal data. This is completely foundational to the law. So under MODPA, personal data means any information that can be linked or reasonably linked to an identified or identifiable consumer. It specifically does not include de-identified data or publicly available information. This tends to be very similar to what we see in the other comprehensive laws. MODPA also has a concept of sensitive data. You can think of this like a special subset of personal data that requires special protections under the law. The definition is on the screen, but I'm not going to read it yet because we're going to be covering it later. So obviously there's a lot there. I'm not going to take the time to do it here, but if you look at the law, you'll find all kinds of sub-definitions for some of these categories, and you can get more detail about what's included or not included. While a lot of this is pretty similar to what we see across the states, there is one glaring unique. MODPA included consumer health data, or CHD, in its definition of sensitive data. Again, we'll be going over that in depth later, so I don't want to get into it too deep. Just know that Maryland is the second state to blend its protections for consumer health data into its overarching comprehensive privacy law. Connecticut was the other state to do the same thing. The others have either not passed special protections for consumer health data, or they've addressed them in a standalone way. An example of this would be Washington, the My Health, My Data Act, which aggressively governs CHD in a state that doesn't even have a comprehensive privacy law. So anyway, more on that later. For now, your main takeaway should be that there's lots of categories of sensitive data under MODPA, and if you're processing any of them, you'll want to pay very close attention to the requirements that we'll be covering soon. All right, so at this point, you should have a pretty good high-level feel for the scope of MODPA. It's concerned with protecting the personal data and sensitive data of consumers within the state of Maryland, as that data is collected and utilized by controllers and processors. So the next thing that we should focus on is the types of businesses that will find themselves subjected to this law. So, like many of these state laws, MODPA includes applicability thresholds. It's really important because it means that the law does not apply to every single business. It only applies to certain businesses that meet certain criteria and thresholds. There are two main criteria that can bring a business under the scope of this law. So first, MODPA applies to businesses that control or process the personal data of at least 35,000 Maryland consumers over the course of a calendar year, excluding personal data controlled or processed for the purpose of completing a payment transaction. That's category one. Second, the law can also apply to businesses that control or process the personal data of only 10,000 Maryland consumers if they also happen to derive over 20% of gross revenue from the sale of personal data over the same period. So I have a lot to say about this. The big idea is that these are much more aggressive thresholds than we see in most other states. And that's especially true when you think of them as a function of state population. To illustrate just how aggressive these thresholds are, I'm going to compare Maryland with the last two states to go live with their laws, which was Tennessee and Minnesota. All three of these states are roughly comparable in population. I think they're each within about 1 million. So they make a pretty good point of comparison. If we first consider Tennessee, its basic processing threshold is 175,000 residents. That's 5 times higher than what we see in Maryland. Tennessee's law even has a minimum revenue component, so it only applies to companies exceeding $25 million in revenue. Maryland doesn't include this revenue concept at all. It's just not relevant when it comes to determining if MODPA applies in Maryland. Then if we look at Minnesota, the basic applicability threshold there is 100,000 consumers, so it's a little bit less extreme of a difference. It's still 3 times higher than we see in Maryland. I fully expect that there will be many U.S. businesses that have flown under the thresholds in Minnesota, Tennessee, and some other states that will now find themselves in a position in Maryland where they need to comply with one of these comprehensive state laws for the first time. If you really look at it, there are a few other states with thresholds as low as Maryland's. Delaware, Montana, and New Hampshire have approximately the same thresholds, but there's a big difference. Maryland's population is much larger than those states. On average, it's something like 5 times larger. So that means if you normalize it out and look at this as a percentage of the population, Maryland's law is a whole lot more extreme than just about any other state. The chart that you're looking at may not be absolutely perfect. I made it really quickly for this presentation, but it does show that the only other state with a law that applies to a lower percentage of the population than Maryland's is in California. The other thing I should mention is that there are a few states that don't use the thresholds at all, Texas and Nebraska. At first glance, that might seem to be aggressive like Maryland, if not more aggressive. But the difference is that those states specifically exclude small businesses from their scope, which Maryland doesn't do. So they're not the best point of comparison, and they're not as aggressive. All this to say, highly recommend that you run the numbers for your business and determine if Maryland's new law is going to apply, even if the other state laws do not apply to your business. I also want to address the topic of exemptions. So much like we see with these other laws across the country, MODPA has applicability exclusions for certain industries and types of data processing. These are mostly in place to avoid conflicts with other federal and state privacy laws. So in other words, Maryland doesn't want to create overlapping or contradicting obligations for industries that are already heavily regulated. That may not be the reason for every single exception, but it's generally where they come from. At the high level, MODPA does not apply to government agencies, national securities associations, or financial institutions that are already regulated under the GLBA. It also has an extremely narrow exception for certain nonprofits in situations where the nonprofit is processing data to help law enforcement investigate criminal or fraud-related acts and to assist first responders dealing with catastrophic events. MODPA also carves out specific categories of data from its scope. This includes protected health information covered by HIPAA, certain medical and research data, and public health information. It also excludes data governed by other federal privacy laws, like credit data under the Fair Credit Reporting Act, driver's information under the Driver's Privacy Protection Act, educational records under FERPA, and even data covered by the Airline Deregulation Act and Farm Credit Act. In addition, personal data collected in the context of employment, so for example, when somebody applies for a job or acts as a contractor or agent, is also excluded. To be honest with you, these exceptions were very difficult to summarize. It's just the way they're written in the law. So please take a look directly at the law if you're on the fence about if your organization should be exempted or not. There were a few things that were notably absent from that exceptions list. MODPA does not have a broad exception for nonprofits. Like I said, there is a comically narrow exception for a very small sliver of nonprofits, but almost all of them will have to deal with MODPA if they meet the processing thresholds. This has been the trend lately, although Tennessee did exclude nonprofits completely within their law. The other thing to mention is educational institutions. So again, this is often a full-blown carve-out. Tennessee excluded them. Minnesota did too, at least for the next 4 years. But in Maryland, educational institutions are in scope. Now, I should point out that the educational records are exempted at the data level, but the institutions themselves are subject to the law. So they don't get a free pass when it comes to protecting personal data that might be outside the scope of educational records. All right. Hope you're still with me. I realize that probably was not very easy to follow along with. So, we should all have a pretty good feel of who MODPA applies to. Let's change our focus and go over the consumer rights that it grants to residents of Maryland. MODPA provides many new privacy rights to Maryland residents. So I'll take a few moments to tell you about each of them. Remember, as I go through these, if your business is subject to MODPA, you're going to need to be able to honor these rights for any of your data subjects that make a privacy request. The first consumer right in Maryland is the right to confirm. So the idea is individuals have the right to confirm if a controller is processing their personal information. The second right is closely related. It's the right to access. So if a controller is in fact processing a consumer's personal data, the consumer generally has the right to gain access to that information. There is an exception for trade secrets here, and in fact, it doesn't just apply to this one, it applies to all the consumer rights. Companies can't be in a position where they're forced to reveal their trade secrets in order to respect consumer rights. The third right that MODPA grants is the right to correct. So this means that individuals have the right to correct inaccuracies in their personal information. And I realize that was a very circular definition, but I think you get it. Next, we have the right to delete certain personal information. So for the record, this is a consumer right that usually comes with some caveats for legal scenarios where the information can't be deleted and that sort of thing. MODPA accounts for this and explicitly states that the right to delete doesn't apply if retention of personal data is required by law. The next right is the right to portability. So if personal data is being processed in an automated fashion, then consumers can request a copy of their personal information in a common and readily usable format. The sixth right in Maryland is the right to disclosure. You'll sometimes see this referred to as the right to list or something like that. The idea is that residents can request a list of the categories of third parties with whom their personal data was disclosed. This is one of Maryland's more unique rights. Some other states like Oregon, Delaware, and Minnesota do have this. Many of the states don't. And there's some differences in implementation. So, for example, in Minnesota, the consumer is entitled to a list of specific third parties with whom their data was shared. Maryland's a little weaker here. MODPA only requires disclosure of the categories of third parties with whom the sharing occurred. Finally, we have one more major consumer right. The seventh right is that consumers have the right to opt out of targeted advertising, sale of personal data, and certain profiling. I can appreciate that they put this one last because it's the most complicated one, and we'll look at each of them in a little bit more detail. Before we get there, I have one comment on this right to opt out. It's really important to understand that MODPA operates under an opt-out model. So in other words, it generally permits the processing of general personal data by default until a data subject decides that they want to exercise their right to stop said processing. The other states use a similar model. Just keep in mind, Maryland is a little bit more complicated than I've just said because of some reasons that you'll soon hear when we talk about data minimization. All right, so we'll cover all three opt-out rights. The first one was the right to opt out of targeted advertising. MODPA provides a very long and lengthy definition of targeted advertising as well as a bunch of exceptions. I'm going to try to keep it simple. Targeted advertising is about displaying personalized ads to individual consumers based on consumer data gathered from unaffiliated websites. As you can imagine, this right has major implications for websites that depend on advertising technologies and scripts and cookies. The reality of it is that many of us are probably running targeted advertising scripts on our websites. It's a very common practice. If I had to approximate, I'd say that more than half of the companies watching this video are probably running some sort of targeted advertising scripts. If you're not sure what's on your website, strongly recommend that you run a free scan on the Captain Compliance app. We'll tell you exactly what advertising trackers we see. The most common of the advertising trackers is probably Google Ads, and then there's some higher risk trackers that show up too. So the Meta Pixel, TikTok Pixel, LinkedIn Pixel, these are all very notable and their use tends to be scrutinized. So anyway, under MODPA, businesses are generally not prohibited from using these tools by default, as long as sensitive data and minors data is not a part of the equation. You'll want to have a good notice on your website and a clear, accessible way for consumers to opt out of the targeted advertising. So that last part was key. Beyond simply providing a notice, you need to give a targeted advertising opt-out mechanism that actually works behind the scenes. Believe it or not, this can be easier said than done. It's kind of a dirty little secret, but in the real world, many cookie consent banners are broken and don't actually respect preferences like they claim to do. This is a big problem because it can make the banners deceptive in nature, and I might talk more about that later if we have time. MODPA also has something to say about dark patterns, which means that any kind of user interfaces that are designed to manipulate the decision-making of data subjects are illegal. This is another very common issue with consent banners. Anyway, you need to make sure that you're blocking the execution of cookies and trackers in response to visitor opt-out preferences. A well-configured consent tool can accomplish this for you. And by the way, this is something that Captain Compliance can help you with. Now, there's an important caveat here. And if you're a well-informed privacy professional, I hope you haven't been yelling at your screen for the last 30 seconds, thinking I'd neglected to mention it. Nothing to do with Maryland's law, but crucial to understand. State-level wiretapping laws and federal laws like the VPPA can still create litigation risks when certain technologies fire without consent, especially analytics and session replay tools, but also certain advertising trackers like the Metapixel. So you should think very carefully about firing any kind of targeted advertising cookies by default, even if MODPA allows for it. There's lots of companies that choose to run an opt-in consent model for targeted ads in the United States just to minimize their privacy risk exposure. This is a complex topic. I don't have any more time for it here. I've done other videos on it, which I'll point you to. The bottom line is that there are still unresolved conflicts between these modern privacy laws like MODPA and the older privacy statutes. In addition to the right to opt out of targeted advertising, MODPA also provides for the right to opt out of sale. So let's start with the definition of a sale. The law states that sale of personal data means the exchange of personal data by a controller, processor, or affiliate of the controller or processor to a third party for monetary or other valuable consideration. It then lays out several situations that don't count as sale. Again, I'll try to summarize. The exceptions include sharing data with processors, disclosing information as part of fulfilling a product or service, transfers to affiliates, instances where the consumer has intentionally directed disclosure or made the information public, and data transfers that occur during mergers and bankruptcies. No surprises there. Most states have something similar. One of the important things to mention is that MODPA has a broad definition of the concept of a sale. It does not limit the concept to monetary transactions only. Instead, it also includes the term other valuable consideration. So, for example, consider a data for data exchange. A company could share personal data with another party and then get back analytics reporting or markets insights data. Under MODPA, this could count as a sale, even though no money changed hands. So this is another area where the laws diverge and they can be a little bit different from one another. Some states define a sale narrowly, requiring an actual payment of money. Maryland takes the broader approach and creates more accountability for businesses. Then we have the last opt-out right that we need to talk about. So if you recall, MODPA provided the right to opt out of certain profiling. So according to the law, profiling means any form of automated processing performed on personal data to evaluate, analyze, or predict personal aspects relating to an identified or identifiable consumer's economic situation, health, demographic characteristics, personal preferences, interests, reliability, behavior, location, or movements. When it comes to the actual opt-out rights, MODPA provides a slightly more constrained opportunity for opt-outs. The law allows for consumers to opt out of the processing of personal data for the purpose of profiling in furtherance of solely automated decisions that produce legal or similarly significant effects surrounding the consumer. So there you have it. MODPA's opt-out is only for situations that have legal implications. If you watched my last video on Minnesota's new law, this is all very familiar. You may even remember that Minnesota had an entirely new and unique right to question profiling decisions, especially those that carry legal impact. MODPA does not have this specific right. This is one of the few areas where Maryland's law is a little bit less strict than Minnesota's. In addition to creating a broad set of consumer rights, Maryland's law also contains several operational requirements for data controllers. Some of these are very standard, others are very unique. So for the next part of our video, I'm going to focus on these different obligations. They're not necessarily going to be described in any particular order of importance. I'm going to try to tackle them in an order that flows. Since we were just talking about opt-out rights, let's stick on that theme for a little while longer because a few of these obligations relate to opt-outs. One of the things that's pretty unique to Maryland is that if a business engages in any activity that demands the right to opt out, so targeted advertising, sale, or profiling, the business needs to provide a clear and conspicuous link on their webpage that allows the consumer to make their opt-out requests. If this sounds familiar, it's because California has a very similar requirement. In California, businesses need to have a specific link on their website that says, "Do not sell or share my personal information." Visitors can then click on it and conduct their opt-outs. Maryland requires almost the same thing. You need to have a link on your website that allows for consumers to easily exercise their opt-out rights. It has to be separate from the privacy notice. It's sort of like something that you would put in the footer of each of your website pages. It probably makes sense to title this link, "Do not sell or share my personal information," because that's what California requires, and it's probably easiest just to settle on that as your standard across the country. But Maryland isn't quite as strict about the precise wording of the link. Now we need to talk about universal opt-out mechanisms. So if you're not familiar with the concept, a universal opt-out mechanism is a browser or device-based signal that automatically communicates a consumer's decision to opt out of certain data processing activities without requiring the consumer to take action on every website that they visit. You can think of this like an automated alternative to using the "do not sell or share" link that I just described. The state laws generally split into two camps when it comes to these automated opt-outs. Some require businesses to support them and others don't. It's about a 60-40 split, with the slight majority of state laws including the requirement. Maryland falls into the group that does require support for universal opt-out mechanisms. This is the more privacy-focused, consumer-friendly path because it gives individuals more ways to exercise their rights. Maryland hasn't explicitly declared which specific technologies need to be supported under MODPA, but in the real world, I can tell you which one you need to know about. It's called Global Privacy Control, or GPC. Global Privacy Control was created in 2020, and its intention was to make it easier for people to express their privacy preferences online. It works by sending a signal from the user's browser or their browser extension to all of the websites that they visit. The signal is transmitted as an HTTP header, a JavaScript variable, or both, and it tells websites that the user wants to opt out of certain types of processing. While websites may handle the signal differently, GPC is widely recognized as an expression of the "do not sell or share" preference. So, under MODPA, your business should support automated opt-outs for targeted advertising, sale of personal data, and profiling. You'll want to make sure that your cookie consent platforms can interpret and respect GPC signals, but there may be additional ways that you need to respect these signals depending on how you collect and process data. So for example, if your website has login features and maintains user profiles, you will likely need to do more to fully respect the automated signals. Disabling certain cookies and trackers may not be enough if you're processing personal data in a deeper way. If you haven't already done so, it is a great time to confirm that your consent management system can both detect and respect GPC signals. I've included a chart here to show that this isn't just a Maryland concern. It's relevant to 12 different states. All of these have more or less the same requirements. So for many businesses, the best bet is probably just to monitor for and respect GPC signals across the whole country. If you need help with this, Captain Compliance can absolutely support you here. For a deeper dive into GPC, I've done a whole video about it, and I've written an article for the IAPP, which is linked in the description of this video. Before we move on, a little bit more about cookie consent under MODPA. I didn't know if I wanted to include this. It's not specifically prescribed by MODPA, but practically speaking, at the end of the day, most businesses will need to use a cookie consent technology if they want to comply with MODPA's opt-out requirements, especially for targeted advertising. If you're not familiar, cookies are small text files. They get placed on user devices. They can be essential, like keeping a shopping cart working, or non-essential, used for things like targeted ads and analytics. The challenge is that the non-essential cookies often raise privacy concerns. They often share data with third parties. So because of this, cookies and web trackers can come under a lot of scrutiny. Getting this right isn't just about having a banner in place. You need to have a thoughtful implementation. The details are very important. For example, any privacy user interface has to avoid deceptive designs or dark patterns. And you also need to make sure that you get the default settings right for various geolocations. And then most importantly, make sure that you're fully honoring any opt-out choices from consumers. So on the right, you can see a simple example of what a compliant cookie banner might look like under MODPA. It's a screenshot of one of our Captain Compliance banners. This is a topic I can really ramble about, so I better move on. All right, I don't know about you. I'm ready to move on from the opt-out topic. Let's talk about all the other things that Maryland's law requires. One of the most important requirements under MODPA is that businesses need to limit their collection of personal data. Now, on the surface, that doesn't sound all that unique. I've said the same thing about other states too. Maryland takes this concept so much farther than any other state has done. You could even say that Maryland's data minimization requirements are even stricter than the GDPR in Europe. In most states that have passed privacy laws, the general theme is that your personal data collection needs to be limited to its stated purpose. And this can actually be a pretty flexible model. So as long as your business is accurately communicating the purpose and ways which personal data is used, the state laws are generally not going to restrict you from performing that processing. There are exceptions for certain types of data, but I'm talking high level. Maryland throws that model out the window and replaces it with a much stricter one. In Maryland, personal data collection needs to be reasonably necessary and proportionate to provide or maintain a specific product or service requested by the consumer to whom the data pertains. So I hope that huge difference is clear. In Maryland, all personal data collection has to be connected to product or service delivery. Collecting data for unrelated purposes is not permissible, even if clearly disclosed, and even with consumer consent. So think about practices like targeted advertising and consumer research. Are companies going to be able to make the case that these types of things are relating to product or service delivery? This wouldn't be a modern privacy law if it didn't contain some ambiguities. So I've been alluding to the big one, and Maryland didn't do any favors to compliance professionals here. MODPA doesn't explain what it means for personal data collection to be reasonably necessary and proportionate to providing or maintaining a product or service. So the reality is that at this time, we don't know exactly how strictly this is going to be enforced by Maryland's AG. Businesses are going to be operating without amazing clarity as they take action in these early days of MODPA. It also seems that this very strict minimization requirement is most aggressively focused on data collection. The law says, unless the controller obtains consumer consent, they may not process personal data for a purpose that's neither reasonably necessary to nor compatible with the disclosed purposes for which the personal data is processed. So, it seems that if a business first collects personal data directly in support of product or service delivery, there may be an opportunity to stretch the use of that data later as part of processing if consent is obtained. That's somewhat implied by the way that this is written. It would also be more in line with the other state privacy laws. All of them are concerned with preventing companies from quietly shifting how they use data after it's been collected. It's just notable that Maryland has much more extreme limitations up front at the point of collection. If consent is being relied on for processing, there's still some considerations to remember. If a consumer withdraws their consent, the controller needs to stop processing as soon as practical, but no later than 30 days after receiving the request. And any consent revocation process has to be just as easy as it is to provide consent in the first place. All right, let's zoom in on sensitive data now. The MODPA requirements here are a little bit different. So here's the definition of sensitive data. Under MODPA, sensitive data refers to data revealing racial or ethnic origin, religious beliefs, consumer health data, sex life, sexual orientation, status as transgender or non-binary, national origin, or citizenship or immigration status. It also includes genetic data or biometric data, personal data of the consumer that the controller knows or has a reason to know as a child, and precise geolocation data. Okay. When it comes to sensitive data, MODPA's minimization requirements apply here too. The law is actually even more aggressive when it comes to sensitive data. So first of all, the sale of sensitive data is just completely prohibited. Then, there's a very high bar to clear when it comes to collecting, processing, and sharing sensitive data. So in contrast with the general non-sensitive data that we just talked about, where collection had to be reasonably necessary and proportionate for product or service delivery, sensitive data has to be strictly necessary to product or service delivery. Again, strictly necessary isn't defined either, but there may be a little bit less ambiguity there in practice because it's framed so strongly. I'll draw another point of distinction between MODPA and these other laws. Most of these laws follow an opt-out model for everything except for sensitive data. So in these other states, sensitive data processing normally requires explicit consent to be obtained before the processing occurs. This is pretty well established across the country. Again, MODPA differs from the rest. So when it comes to sensitive data, there's just no flexibility to be found by relying on consent. Businesses don't even have the option to rely on consumer opt-in or consent to justify processing or sharing sensitive data more liberally. As a side note, Maryland is going to require that businesses perform data protection assessments for any and all sensitive data processing, and I'll be talking about that in a moment. All right, we've talked about sensitive data, which is a subset of personal data. Now let's talk about consumer health data, which is a subset of sensitive data. At first thought, this category might seem a little confusing. Why is consumer health data, also known as CHD, even included in this law? So think of it this way. Consumer health data is health-related info that's collected outside of a traditional healthcare setting. So for example, your smartwatch tracks your health rate. You might have a fitness app that logs your workouts or a sleep tracking feature on your phone. Over the past 20 years, this kind of data has become a much bigger part of our daily lives. But the problem is, while it's incredibly sensitive, it often isn't covered by laws like HIPAA, which only apply to traditional healthcare providers and insurance companies. So because of that gap, regulators have started to pay close attention to CHD. The Federal Trade Commission has made consumer health data an enforcement priority, but there's still been a push for even stronger state-level protections. Back in 2023, Washington and Nevada passed the very first standalone laws related entirely to consumer health data. Washington's law was especially strict, ironic because the state didn't have a comprehensive privacy law then, and in fact, they still don't, but they do have a consumer health data law. Same year, a third state, Connecticut, took a different approach. So instead of doing a separate law, they amended their comprehensive law to include specific rules for CHD. They were the first state to integrate CHD protections directly into their broader framework. Maryland is following that path. So rather than creating a separate law, MODPA is building in protections for consumer health data just like Connecticut did. Let's talk about those protections. We should probably start by looking at how MODPA defines CHD in the first place. So MODPA says that consumer health data means personal data that a controller uses to identify a consumer's physical or mental health status. It then goes on to specifically mention that consumer health data includes data related to gender-affirming treatment or reproductive or sexual health care. The law doesn't actually contain very many unique requirements for CHD. Because it's considered a form of sensitive data, it's already subject to fairly extreme levels of care. All those restrictions we already covered, and the unique obligations like performing data protection assessments all apply to CHD. However, MODPA does have some specific requirements for controllers when it comes to sharing CHD with employees, contractors, and processors, and there's also a geofencing restriction. So the law prohibits the use of geofencing technology to target individuals within 1,750 feet of a mental health, reproductive health, or sexual health facility for the purpose of identifying, tracking, or collecting data from, or sending any notification to a consumer regarding their consumer health data. We have one more unique category of data to talk about, and that's children's data. So MODPA has specific requirements to protect minors. These protections go further than we typically see. Under MODPA, a controller cannot process a minor's personal data for targeted advertising or sell that data if the controller knew or should have known that the consumer was under 18. This is notable because most other state laws set the cutoff at a younger age. In some states, it's as low as 13. Maryland's choice to use 18 expands the group of minors who end up being protected. MODPA's definition of targeted advertising covers ads that are selected based on a person's activity over time and across unaffiliated websites or apps. So it doesn't include ads that are based solely on a user's activity within the controller's own individual site or app. The distinction matters because families often share devices. If there's any indication that a device is used by someone under 18, businesses should take care not to serve targeted ads to that device, even if it's used by an adult in the household. This is obviously complicated. It's going to take careful planning by advertisers and controllers. Companies are going to need to reveal their data collection and advertising practices to make sure that they're not inadvertently targeting minors or selling their data. The next major requirement has to do with privacy notices. So, one of the key requirements of this law is that controllers have to provide reasonably accessible, clear, and meaningful privacy notices. They then need to include several key elements. So first, the notice should outline the categories of personal data being processed, especially for sensitive data. It should also explain the purpose of the processing that's occurring. If it happens that the controller is engaged in targeted advertising, sale, or certain profiling, this needs to be very clearly disclosed. Next, Maryland requires that privacy notices describe how consumers can exercise their rights and appeal any corresponding decisions from controllers. We'll talk more about that request processing shortly. Another element that the notices need to include is information about the categories of third parties with whom personal data is shared, as well as the sufficient detail for the consumer to understand that processing. On a similar note, the notices need to include descriptions of the categories of personal data, including sensitive data, that the controller shares with third parties. We hit on this earlier when we were talking about the right to disclosure. Finally, privacy notices should provide contact information, which has to include an online mechanism. So, unlike California, Maryland doesn't require a toll-free number as a contact method. Instead, the main requirement here is that at least one of the contact mechanisms has to be online. Before we move on, I want to point out one potential challenge. This is not exclusively a Maryland issue, but you'll soon see why I'm bringing it up. As more states pass these comprehensive laws, the state AGs are making it clear that the one-size-fits-all approach to privacy disclosures is no longer acceptable. California has long required businesses to clearly list consumer rights under the CCPA. Now, other states are following up with their own requirements, many of which conflict. Oregon's AG office has warned that if a company specifically describes Californian rights, which they probably need to do for CCPA compliance, it must do the same for Oregon with equal clarity. Delaware's AG has shared its own take, discouraging businesses from using aggregated or generic language that masks state-by-state differences. So at this time, in practice, many companies still take the approach of only listing Californian rights or You often see them lump all the state rights into a single generalized section. This is getting increasingly risky, and we don't yet know what sort of guidance Maryland and their AG office is going to offer. The way that we're dealing with this at Captain Compliance is by doing layered state-specific disclosures that accurately convey the consumer rights for every single state. So if you think that model would work for your company, could be something for us to talk about. We can definitely help you with that. Okay. I mentioned that Maryland requires privacy notices to include information about how consumers can exercise their rights. Let's talk more about data controller accountabilities when it comes to these data subject requests. If a consumer in Maryland wants to exercise any of the privacy rights that we went over earlier, businesses have to respond to the requests and fulfill any of them that they're obligated to. So as a side note, there are some situations where a business can justify a decision to deny a request. So this could be the case if a consumer request would interfere with a business's legal obligations, or another example might be if the request falls outside of MODPA's personal data scope with a request involving de-identified data. There's also some very important timing considerations here. Generally, MODPA requires that companies respond to consumer requests within 45 days. The law does allow for a one-time 45-day extension if the request is particularly complicated, or maybe if the data subject is sending in a very high volume of requests. But even in the case of an extension, there still needs to be communication with the data subject within that first 45-day window. All of this is pretty standard across the state laws. It's probably a good time for me to mention, while the law doesn't explicitly require it, I highly recommend having a structured mechanism for processing these data subject requests. An example of this would be a special purpose portal for taking in requests and managing their responses. That way you can make sure that the requests are all properly formed, tracked, and managed to completion by appropriate team members. This is something else that Captain Compliance can help you with, and we can even automate the fulfillment of your most commonly received requests so that you don't have to do them all manually. Moving on. Another aspect of MODPA that controllers need to address is the requirement to perform data protection assessments before conducting certain types of processing. Data protection assessments are required to be performed on an ongoing basis when the controller is processing personal data in a way that presents a heightened risk of harm to the consumer. So this can include situations where the business is involved in data processing for the purpose of targeted advertising, sale of personal data, or certain profiling. The law even references performing assessments of algorithms, so it seems that AI is going to be a point of focus here. The assessment also needs to be performed if the business is processing any sort of sensitive data. So the whole idea behind these assessments is that they need to weigh the necessity and proportionality of the processing of personal data to make sure that the risks don't exceed the benefits of performing that processing in the first place. The law lists many factors that should be considered within the assessments, including the use of de-identified data, consumer expectations, the context of the processing, and the nature of the relationship between the controller and consumer. If requested, any historical assessments need to be made available to the Maryland Attorney General. It's possible that they might be requested as part of a regulatory inquiry. The expectation is that assessments will be performed for any processing that occurs on or after October 1st of 25, the same day that MODPA goes into effect. Notably, Maryland doesn't seem to demand any specific retention requirements for these data protection assessments. This stands in contrast with some states like Minnesota, which requires them to be kept for 5 years. Probably makes sense to retain them for a similar amount of time, but in Maryland, this is left to the business to determine. The next controller requirement has to do with security and data protection. MODPA requires businesses to take reasonable steps to protect personal data. The law states that controllers shall establish, implement, and maintain reasonable administrative, technical, and physical data security practices to protect the confidentiality, integrity, and accessibility of personal data appropriate to the volume of the nature of the personal data at issue. So, Notice, MODPA doesn't really require anything specific. This is a very high-level requirement. The cybersecurity practitioner in me appreciates this. I think it's probably best that the state laws stay out of the practice of prescribing specific cybersecurity controls, and most states take this path. Although Minnesota did include very specific inventory requirements in their law, and inventory is definitely a data protection control. Anyway, there's lots of different types of cybersecurity controls that are probably necessary to protect personal data under MODPA. Access controls, encryption, training. There's no way I can get into the detail here. Just know that your business will need to maintain a cybersecurity program, but they'll have flexibility when it comes to the actual specifics of how personal data is protected. We also have MODPA control requirements that have to do with non-discrimination. Two angles to this one. The first is identity-based. So, with few exceptions, businesses are prohibited from using personal data in ways that unlawfully discriminates against people based on their protected characteristics. Think race, color, religion, national origin, sex, sexual orientation, gender, or disability. And then second, businesses can't discriminate against consumers for exercising their privacy rights. So you can't deny them services or charge higher prices or reduce quality just because somebody made a data subject rights request or otherwise exercise their privacy rights. While we've gone over a very long list of controller requirements, we should also look at what MODPA requires from processors. So there's a lot of details in the law. The high-level summary is that the processor needs to follow instructions provided by the controller to help them fulfill their MODPA obligations, like responding to consumer requests and providing information that's needed to perform accurate data protection assessments. There's also a requirement that controllers and processors establish contracts with one another. So there's a bunch of requirements just for this contract piece alone. For example, the contracts need to outline processor requirements, like maintaining the confidentiality of personal information, deleting or de-identifying data when appropriate, or making sure that subcontractors to the processor meet the same privacy standards. One important element that is included in this law is that processors have to allow their privacy practices to be audited or assessed, either directly by the controller or by an independent assessor. So this way, the controller can verify that their vendors are meeting their legal obligations. I've done a lot of cyber contract reviews in my day, and I can tell you this is a very hotly contested contract element a lot of the time. Not something that processors are always excited about agreeing to. MODPA makes this all the more important to have established in the contracts. At the end of the day, these terms help make sure that processors play a clear, supportive role to the controller and that accountability is maintained wherever the data is handled. All right, that was all the main requirements of MODPA, so let's shift our focus to enforcement here. The Maryland Online Data Privacy Act will be enforced exclusively by Maryland's Attorney General. Even though the law will be in effect on October 1st of 2025, Maryland has signaled that they will not be enforcing the law over the first 6 months that it's in effect. So you can expect enforcement to begin sometime on or after April 1st of 2026. Similar to all of the laws outside of California, no private right of action, meaning that only the Attorney General can take enforcement actions when they believe that a business is violating the law. However, Maryland consumers will be able to file complaints to the AG if they feel that their privacy rights have been violated by a business. One thing about MODPA that's a little bit more business-friendly is that it includes a discretionary cure period, which can give businesses 60 days to fix issues before facing penalties. This is actually somewhat generous. There's a bunch of states that have shorter 30-day cure periods, but it's not going to last for long. Maryland's cure period is going to sunset and expire on April 1st of 2027. So the first year of MODPA enforcement might include a little bit of extra grace from the AG, but at some point that's going to change and they're going to move directly to enforcement. We also need to talk about the MODPA penalty structure. So the Attorney General can issue fines of $10,000 per violation, plus additional fees and costs. If it's a repeat violation, the penalties can skyrocket to $25,000 per violation. Yet another reason that MODPA might represent more risks to your business than these other state privacy laws. In most states, the fines are capped at $7,500 per violation, and some of them don't ramp up the fines for repeat violations. All in all, MODPA's penalty structure skews higher than most. So, it should be clear that your business's compliance with MODPA is definitely not something you want to leave unexamined. As we wrap up here, I've done my best to summarize all this material down to my few core recommendations. Obviously, there's a lot of important things that may not be shown here, but I did do my best. So first, make sure you understand whether MODPA applies to your business, and then take the basic steps to communicate with Maryland consumers. So that means running the thresholds, checking for exemptions, and then making sure that your privacy notices and request handling processes are ready for Maryland residents. Second, you'll need to apply Maryland's strict data minimization rules. Remember, you can only collect data that's necessary to provide or maintain a product or service, and you can't rely on consent to justify collecting extra data upfront. Third, take a hard look at your opt-out infrastructure. So you need that clear and separate opt-out link. You need to make sure that you're capable of respecting GPC signals. Focus on your cookie consent technology as well. It has to be able to stop targeted advertising technologies and tracking tools from firing once a user opts out. Finally, make sure you're protecting your high risk and sensitive data. So sensitive data includes consumer health data and children's data, both of which has special rules under MODPA. The examples include targeted advertising restrictions for minors and then the geofencing restrictions around the consumer health data. More generally, with all sensitive data, processing is only allowed when it's strictly necessary to deliver a product or service, and you have to conduct data protection assessments for any of that sensitive data that you process. Remember, even though MODPA goes live next week, and many of these obligations need to be implemented at that time, enforcement won't start until April. So make sure that you use that time effectively to build up your privacy program in Maryland before next April hits. That's all my material for today. I hope that it was informative and that it wasn't too deep. I hope you have a clear understanding of the steps that you need to take to comply and reduce your exposure. If you need help getting your organization ready for compliance, we'd love to support you. I'd love to share more about that with you one-on-one. If you do need help with privacy compliance, our website is www.captaincompliance.com. I'll put the link and additional contact information in the stream description. Thank you so much for watching.